welcome to Making the Case. I'm Yodit Tewolde. Tonight, we're looking at some developments in the case against 3 of the former police officers charged in George Floyd's death, and also a delay in the fight to pass a police reform bill named in Floyd's honor. Today in Minneapolis, attorneys for both the state and the 3 former officers appeared before the Minnesota Court of Appeals as prosecutors try to get an additional charge added to the case. Thomas Lane, J. King, and Tu Tao are currently charged with aiding and abetting second-degree murder and second-degree manslaughter. Prosecutors now want to add an additional count of aiding and abetting third-degree murder. Defense lawyers argue that proving this charge would be legally impossible since aiding and abetting is an intentional act and third-degree murder, as defined in Minnesota law, is unintentional, requiring only that a defendant act recklessly. Derek Chauvin was convicted of third-degree murder, but including the charge was a controversial decision. And that's because the exact meaning of the Minnesota third-degree murder statute is the subject of a pending appeal by Mohammed Noor, the police officer convicted in the killing of Australian woman Justine Dimond. A 3-judge panel has 90 days to rule on whether the charge can be added in this case. 3 former officers are scheduled to go on trial next year. Joining me to break all of this down, BNC legal contributor and veteran prosecutor Paul Henderson. Hey, Paul.
Hey, how's it going, Yodit?
All right, so I want to start with the case against the 3 former cops in Minneapolis. They could be facing additional charges of aiding and abetting third-degree murder. Give us the breakdown of the legal arguments from both sides.
Well, here's the thing. I think the prosecution really wants to take advantage of, now that they've got a conviction that's still under appeal, but now that they've got the conviction for murder, we have a definition of what took place that they want to try and highlight or increase in terms of the accountability or the exposure for the pending charges that are coming against the 3 other folks that were there at the scene, to make sure that they cover as many bases as they can. Now, what I think is interesting about this is that it is a little bit of a legal stretch to expand the liability, and as we know, third-degree liability is less than second-degree and certainly less than first-degree, which is what's at issue here. At the heart of this is a conversation about charging and about intent. That's what's being considered here by both the Court of Appeals that's reviewing whether or not they're going to be allowed to amend these charges. But at the end of the day, I don't think it's going to make that much of a difference in terms of both what the prosecution is going to do and what these individuals are going to face in terms of holding them accountable, because that process is still in the pipeline and is going to happen anyway.
Well, Derek Chauvin was convicted of third-degree murder, but there was some controversy about adding the charge because the entire definition of Minnesota third-degree murder statute is the subject of that appeal by Mohammed Noor, the black former cop who was convicted of killing Justine Dimond, a white Australian woman. So how can Noor's appeal, I know you said that how does his appeal actually make a difference for Chauvin's upcoming appeal, and how these appellate judges are going to rule in the case against those 3 officers?
I don't know that it's going to make that much of a difference, because even if they rule, well, first of all, let's talk about the appeal first. So for the appeal with Chauvin, that's already in the pipeline. I don't think that appeal has a very strong basis, and I am not thinking that it's going to be approved, but let's just say that it does and it goes through anyway. It's going to have very little to do with these other 3 officers and what they've been charged with and how they've been charged with. And here's the kicker to all of this. At the end of the day, even if they are not, the prosecution is not allowed to charge it as third degree, and we'll come back to that because I think there's a significance to talking about the differentiation between second and third degree. But even if they are not allowed to charge as a third degree, the prosecution has the option, if they want to, and if they think they can prove it, to charge them directly. The issue is aiding and abetting defines that the prosecution must prove intent, and they can charge any or all of those officers as principal actors, meaning if they can show and prove intent, they can charge them independently in another way, which is why I don't think it makes that much of a difference. And that, again, shines the light on how much discretion prosecution has in cases like this. But coming back to this whole issue in the first place of the differentiation between second and third degree, both with Chauvin and with these officers, the issue is that level of culpability is less, but the exposure and the accountability is less as well. And that, to me, is the real issue. When we're talking about, if we take a step back, and talk about what is the accountability for these officers. That's what's at the heart of this entire conversation. And part of it is defined by how prosecution plays its role in defining accountability, but only in the criminal lane. There's still accountability in the civil lane for the lawsuits, and there's accountability on the legislative and external side of it as well, because none of this accountability in the criminal lane speaks to anything regarding the policies, only to the accountability of those officers for that specific incident. And that's a case-by-case analysis that has to be proven individually by prosecution.
All right, well, let's move to Washington now. California Democrat Karen Bass has led the charge to try to get the George Floyd Justice and Policing bill passed. Democrats set a deadline of next Tuesday, the one-year anniversary of Floyd's death, for a vote. But Bass now says that isn't happening. Two sticking points remain. Okay, Paul? Abolishing qualified immunity, which would allow victims of police misconduct and brutality to sue officers in their individual capacity in civil court, and the color of law statute. Abolishing the statute would make it easier for the Department of Justice to bring criminal charges against individual officers for violating a person's civil rights. So, where do negotiations stand as it relates to qualified immunity?
I think both sides are talking about it, but they're obviously not in agreement. And I believe the announcement about it not being ready for the anniversary is managing expectations. And so there's a lot of work that needs to be done on both sides if something's going to come out of it. But what I'm paying attention to is the language and the conversation from the folks that are at the table saying and articulating that this is not going to be a cure-all. And I think that that's really important, because those sticking points that you just articulated and defined for us are some of the really key issues in this bill. But understanding and knowing that it's not going to be a cure-all still means that we have to manage expectations about what communities are demanding from this bill at a federal level. Certainly, there have been actions that have been taken at local levels and at state levels, but at the federal level, part of the momentum behind the George Floyd bill, separate from just the trial that just took place, is to address the vacuum that had been taking place at the federal level to address policing reforms. And this Section 242, that's the section that defines qualified immunity and how and when police officers can be charged, has been at the heart of it, because those numbers have been abysmal throughout the history of this country. And the whole point is not to have more officers charged. The whole point is to address the substantive core issues that officers are using force disproportionately in the first place. And this is a complicated box to unpack. And although it's clear to me what the outcome should be with George Floyd bill in terms of what's ultimately going to be supported, apparently the Republican Party is still not in support of some of these key issues. And I think they're issues that are really important. I don't see Karen Bass walking away from it without some sort of compromise from the other side before we get a bill signed.
Well, she said that it wasn't going to be passed by next Tuesday, but she does think it'll be passed a few months from now, which to me is politician speak for no time soon. But isn't it more important to get a substantive bill that actually has an effect rather than to rush to get a bill passed on an anniversary that seems more performative?
100%, but at the same time, these transgressions are continuing, and we see it again and again every day when we turn on the news, that there's a new story reflecting that we don't have leadership, we don't have guidance, we don't have articulated clear rules of law that are changing the systemic problems that we've had with race-disparate policing. That's the problem. That pressure is not going away in every life loss. Every disproportionate use of force against a member from the communities of color and the LGBT community and all of the other disenfranchised community is a resounding reminder that we need to take action now, and politics should not be in the way of that, especially when we are all clear about what the problems are. This qualified immunity issue is not something that is new, and we've missed opportunities from the Supreme Court to take it up and to clarify what the issue should be. And now is the time for action. And I don't believe that communities are very patient about waiting longer for known best practices that have not been enacted for political gamesmanship at this point. That's the frustration. And so I expect that Karen Bass, I expect that Cory Booker, I expect that there are colleagues on the other side of the fence that are working on this during this release or break that they have are still going to be working behind the scenes, trying to come to some sort of agreement sooner rather than later. That pressure is real, and it's not going away.
All right, veteran prosecutor and BNC legal contributor Paul Henderson, as always, thank you so much.
Thanks for having me, Yodit.